So for those of you who don't know me, I am Martha Ambrose. I am the Executive Director of Cal-ISBOA, and I know some of you don't deal with Cal-ISBOA regularly. You're more on the communication side of things, so welcome. This is a topic that's near and dear to Cal-ISBOA's heart because we just redid our website. So we are learning about our ADA obligations as well. So the timing of this is very good. Without further ado, I'm going to go ahead and introduce Jenna Goodrich, who is the Area Vice President at Arthur J. Gallagher, and she works with schools and nonprofits to help them manage their risk in all different areas. And through her work with through her work, she's developed a relationship with I don't know, do we pronounce it AAA track or AAA track? I would say
AAA track.
AAA track. That was my instinct. AAA track. She worked with them to provide them with their insurance and developed a relationship with them that way. Learned about what they do, and she's really been concentrating on sharing the knowledge she's picked up and educating her clients over the last 6 months about the increased awareness and around ADA website compliance. Jenna?
Wonderful. Thank you so much, Martha. Good morning, everyone. Happy Wednesday. On behalf of the education practice here at Gallagher, specifically Darryl Milgram, National Director for Independent Schools here, we want to thank you all for just attending today and taking the time out of your busy days. We have been doing we've had a lot of great feedback working with Wilson and Elser and AAA track in regards to this topic. And we're pleased that we're able to offer Cal-ISBOA members the opportunity to learn about just the rising exposure here that schools are facing and how to avoid a lot of these costly litigations. I want to thank Adam Bialik, partner and chair of the National Intellectual Property Practice Team of Wilson and Elser, Kara Thorvaldsen, I'm so sorry, I never can enunciate your name, Kara, attorney at Wilson Elser as well, and Lawrence Shaw, CEO of AAA Track, just for taking the time today to educate everyone and really figuring out how schools can best protect themselves when it comes to ADA website compliance and providing you with some of the tools that will help you avoid those lawsuits. So without that said, I'd like to hand it over to Adam and Lawrence.
Let me just say, if you have questions, just put them in the chat. And if everybody, I think everybody's muted, but if you're not muted, just go ahead and mute yourself. And we'll be monitoring the chat, but we will plan on answering questions at the end of the presentation.
Well, thank you. Good morning. I'm Adam Bialik from Wilson Elser. We're a national firm of approximately 900 attorneys in 39 offices throughout the country. My partner, Kara Thorvaldsen, will be joining me today on this webinar, and I want to start by thanking Jenna Goodrich and Darryl Milgram at Gallagher, as well as Martha Ambrose and Andrea Marcus at Cal-ISBOA. Our friends at AAA Track, Shaw and Jamie Whitwell, and I'm sure I'm missing the people who are responsible for setting up this seminar, but we hope that you will find it informative. Next slide, please, Lawrence. So today's webinar, COVID-19 moves ADA compliance for websites to the forefront, will focus on 4 primary objectives. 1, how COVID has changed the landscape for the need to become ADA accessible for websites. 2, the implications of the Americans with Disabilities Act on a business owner's responsibility or an operator's responsibilities in operating in an online environment. The challenges faced in achieving and importantly maintaining compliance. And 4, opportunities for risk mitigation. Simply stated, for the last 30 years in which the ADA has been in existence to protect against discrimination of persons with disabilities, business owners and brick and mortar operations have been primarily concerned about the physical premises on which were located. However, the same principle applies to websites. Remember, approximately 1 out of every 5 Americans has a disability. So if it's not you, one of the 4 people you're currently with is likely to have a disability. Now, of this number, approximately 5 million are youth, and there are some studies that actually come in with even higher figures. So let's talk about the issue a little bit. Now, imagine if you approached a restaurant, but you couldn't find the door to get in. You see your friends are inside, but you can't join them. Maybe you do get inside, but you can't order food while others can. This is the feeling that you would experience, similar to the situation faced by individuals with disabilities when interacting with a website or a mobile app that is not ADA accessible. Specifically, some elements commonly seen in these types of issues are no alternative text on images. It's called alt text. So images on every website must include an element called an alt tag. That gives screen readers an idea of what the image is for. So for example, if you're selling a black sparkly purse, you would want the alt tag to read just that. Otherwise, there's no way for the person with vision impairment to know what is being shown on the screen. No accessible drop menus. So an accessible drop-down menu allows those with visual impairments the ability to click through all pages of a website. If this isn't set up, again, it's a frustration or an obstacle for the person with the disability. No keyboard access. Screen reading software looks to keyboard movement to help visually impaired users navigate web pages through a website. If keyboard tabbing abilities aren't in place, someone using a screen reader would have a hard time accessing pages throughout the website. Can we go to the next page, please, Lawrence? So the changing landscape, and actually we had some debate over whether we called this the changing landscape or the changed landscape, because I think at this point it's probably changed already. But I want you to think back to about a year ago. You were regularly shopping in supermarkets, retail stores, going to movies, going to restaurants. When parents thought about their kids going to school, it was more, what are they going to wear? How are they getting there? How are they getting home? What do I need to give them for lunch? Universities were dealing with controlling on-campus assaults and fraternity pranks. How a year can change everything. Most likely, you may be ordering groceries online, having products delivered, picking them up curbside after ordering online, ordering takeout, and trying to play a role in online learning yourself. School, to me, used to be a location. School, I go to a place. Now it's more of a concept. And remote learning has moved to the forefront, and even when COVID subsides, many of these changes are likely to remain in some form or fashion. So when COVID first, many businesses and places of education did not have significant interactive websites. It's just we weren't yet. They were looking at that as something that would be coming probably within the next decade. However, within days, everybody had to rush to get online or they would perish. Think about how many businesses or even schools, that had to close because they weren't set up for it. So within days, they had to rush to get things squared away. And they often turned to third parties for support and service. For speed was paramount. How quickly can we get up and running to support our students, our families, our clients? And the problem with this need for speed to get online quickly and get up and running is, what I learned as a kid, that haste makes waste. And when you're rushing to get things done, issues are often. So, common question would include, whether or not the appropriate time and money was spent to make sure that the web developer who was working with the website was familiar with accessibility rules, or were internal staff or inexperienced or overstretched contractors used. Remember, this is a time where everybody needed to get on immediately, and you only had a certain number of third-party experienced vendors who were willing to and able to do this type of work. And everybody was looking to the same vendors for this, so the vendors were stretched thin, and the vendors needed to rush through things. So you also have to ask whether or not the institution stopped and pondered how to make their websites compliant. Was this even a consideration for you at the time, or did you just say, we need our classes online, we need to get the teachers to be able to interface with the students and with the parents? How do we do this? What's the quickest way to get us online? The key is to get a platform for education to continue, not to ensure that best practices were followed. And when the resources are stretched thin, time is short, errors can slip through the cracks. So now we're trying to figure out, well, what went right, what went wrong, what do we need to do? So how bad is the problem? Can you move to the next slide, please, Lawrence? So on the left side, this graphic shows that most organizations, approximately 71%, believe they have the systems and services in place to deliver compliance. So for those of you who are listening, 7 out of 10 of you think that you have the resources in place to do what you need to do in order to be compliant. But like the treadmill that sits next to my bed, just because it's there does not mean it's being used. And similarly, although many companies, educators, online operators have these tools to be compliant, the majority are not. In fact, if you look at the right graphic on this page, despite the fact that most believe they have the tools to be compliant, only 6% of websites are actually considered low risk. So if we were in a live room, I'd tell you, look around the room, only 1 out of 20 of you are actually considered low risk. Since we're online, and I can see there's about 29 participants, you figure that on this call, there's maybe 2 people that are compliant. It's fairly low. And accordingly, at the present rate in which plaintiffs' firms are getting involved in accessibility websites, every website could actually see in the next 4 years. So again, there are other statistics out there that claim the problem is even worse than this. There's a vendor called WebAIM that conducted an accessibility evaluation of home pages in February 2019 and again in 2020. It was right at the start of when COVID was starting. So this data that I'm about to give you was pre-COVID. So they did an evaluation of home pages for the top 1 million websites. And then they also looked at over 100,000 additional interior pages. Now, across the 1 million home pages, they detected approximately 61 million distinct accessibility errors. This is just the home page. And that was an average of about 61 errors per home page. And you'd think that people are getting more sophisticated, this would improve. That number actually increased 2.1% from 2019 to 2020. So as much as we think that we're getting better with this, we're not. And again, that was before COVID. So the most common failures that WebAIM had found were low contrast text. That's so that somebody with a vision impairment can't really tell the difference. Missing alternative text for images, empty links, missing empty buttons and language. We go to the next page, please. Thank you, Lawrence. So certain more exposed than others. The education, again, as you all know, is one that's been very hard hit by COVID and had to move quickly online. 86% of websites were shown to be at high risk as of the first week of November. So this is a survey that had been done of educational websites in the first week of November. This same company did a survey 2 months prior in September, and they actually had found that there had been 87% in the high risk. So you look at that and you say, okay, we're further down the road. We're now, September, we're at least 6 months into the heavy part of COVID where people were shutting down. Now we're 8 months into COVID, it should be better. And it only improved by 1%. What was even more concerning was that 0% were in the low risk category. That means regardless of whether you're high risk or medium risk, every educational website had an issue with accessibility. We also, this same study looked at certain government sites in California to see who was at risk. And they found that 83% were at high risk, 11% at medium risk, and 6% were at low risk. Now, this was really odd because in November, more sites had actually entered the high risk category than from September, and a few had improved to increase the low risk sites. So the medium risk went, you went either one way or the other. You either went further to the high or further to the low. But again, with an 83% in the high risk, it's almost meaningless because almost everybody is subject to a high risk. So what exactly is compliance and where are the risks? Allow me to presentation to my partner, Carol Thorvaldson, who will take you through the next set of slides. Kara?
Thank you, Adam. So when you're looking at ADA or anti-discrimination laws, there is a complete patchwork of laws and regulations that can apply. There are applicable laws at the federal, state, and local levels, and these are subject to both government enforcement by private civil litigants employing our state and federal courts. What are the standards? Generally, a consensus has come to be that the standards that apply are the Worldwide Web Consortium's Web Content Accessibility Guidelines, and there's a couple different versions of those. At the federal level, the U.S. Department of Justice has not taken the position that those regulations actually apply formally to the ADA. They haven't done any formal rulemaking on that yet. But with that said, in all of the litigation that we've seen, those are the standards that are being cited by plaintiffs and that are generally being accepted by the courts. For its own part, the US government has said that the WCAG 2.0 standards apply to its operations, as well as to federal contractors and programs receiving federal funds. That's pursuant to the Federal Rehabilitation Act. There's also, relevant for California schools and businesses, the relatively new California Consumer Privacy Act, which makes specific reference to the requirements of WCAG 2.1. And there are a number of new California regulations and laws that will apply. And for your convenience, we've appended them to the end of this presentation for your reference. In addition to those general laws that apply under the Rehabilitation Act and the ADA, there are industry-specific statutes that apply at the federal level and that federal agencies have taken steps to enforce against various companies, including the airline industry. And of course, there's just a bevy of state and local laws that may apply, including city ordinances that might affect anti-disability discrimination. Lawrence, could you go to the next slide, please? So what we need to do in order to comply with the ADA and other similar laws is to make reasonable adjustments that make the websites more accessible. What the standard of reasonableness is a little bit hard to define, but generally, substantial compliance with the WCAG 2.0 or 2.1 standards will meet that criteria. So examples that Adam talked about a little bit earlier would, you know, create various ways that people with disabilities could access the content. So we're talking about making the font size adjustable, increasing color contrast, ensuring that text is searchable, providing image descriptions, providing captions or transcripts for audio content, making the site navigable by keyboard, as Adam mentioned, and generally making sure that the site is well organized and that links, input fields, and headings are clearly labeled and easily understood, whether by visual or auditory means. Could you go to the next slide, please? So the reasons to be compliant under the applicable federal and state law are that there are substantial penalties if you're not compliant. If you get sued under the ADA, it's a strict liability statute, meaning that as well-meaning as you might be, you still might be liable for violating the ADA. It doesn't matter if you meant to comply or if you meant to discriminate, the standard is still the same. If the website is not accessible, it's in violation of the law. What that leads to is under the ADA, there aren't damages available, but there are the cost of defending it, which is your own legal fees. There's a fee shifting provision under the statute, which allows a plaintiff who's successful in their lawsuit to recover their own attorney's fees. And that really becomes a driver in these cases, because the more you litigate, the more you end up potentially having to pay the other side for their own legal fees. Injunctive relief is available as well. So a successful plaintiff could get a court to impose upon your organization certain requirements as to how you run your site or your business or your school. And then of course, under the ADA, there's the possibility of class actions and also of successive claims. So it's really difficult to get a claim fully resolved if you settle with one plaintiff, because there could be a different plaintiff, perhaps with a different disability, that comes along and finds a different accessibility barrier and then files their own lawsuit. So it's a little bit of a game of whack-a-mole. And then of course, under state law, including under California law, there's the possibility of getting damages for violations. Next slide, please. So this illustrates sort of the growing expense that dealing with these suits is having for businesses and organizations. Typically, when a claim comes in, if it's just a demand letter, it could be something in the range of $8,000 to $10,000, where you have a plaintiff demanding that you make certain remediation to your website and also pay their attorney's fees in the range of, as I said, $8,000 to $10,000. Once that goes into suit, because a lot of times these letters get ignored because people don't know what to do with them, once it goes into suit, the price typically goes up. And these plaintiffs' attorneys have sort of a going rate for what these claims are worth, because they file a lot of them and they communicate with one another. So they keep track of what the settlements are going for. So if you get into a situation where you're having to defend a lawsuit, even if you settle at a very early stage, the cost of the entire enterprise, when you look at the defense costs, the settlement costs, and anything out of pocket for remediating the site or hiring a consultant, you can be up in like the $50,000 range. If the organization really wants to fight it, which more businesses are, because some businesses are now in a better position to be fighting these lawsuits because they have taken greater steps towards compliance. It doesn't mean that the costs of the suit are going to go down. In fact, if anything, they may go up because you're spending more money on legal fees. And that's where we see that the claim costs can now get into the six figures. Those costs, of course, don't even take into account the intangible costs, such as the distraction to your employees and your legal team, the potential harm to your reputation, and bad publicity. Next slide. Oh, and this just is to underscore the idea that everyone's at risk. There's no exemptions for nonprofits. There's no exemptions for people who are nice or people who don't mean to discriminate. This is affecting retailers, ones that have brick and mortar businesses, ones that are solely online. We've dealt with art supply companies, galleries, jewelry makers. You can see that the slide shows, bicycle retailers, restaurants, every type of industry is being targeted right now. The plaintiffs' attorneys have kind of worked their way through some of the big name brands and companies and institutions and are now kind of going to the smaller businesses, schools, and organizations. Next slide, please. So one of the examples of a case that we thought was of particular relevance to this audience was a suit filed by the National Association for the Deaf against Harvard and MIT. The litigation went on for 4 years and ultimately settled. And the issue was that these universities were posting a lot of publicly available online content, videos, massive open online courses, but folks with hearing disabilities weren't able to access that content easily. And after 4 years of litigation, Harvard entered into a settlement where it agreed to actually provide captions or transcripts for all of that online video content. And as part of the settlement, which was on a class action basis, the plaintiff's attorneys requested fees of $1.5 million. So you can see how the size of these things can really grow. And with that, I will hand it back to Adam. I think you're on mute.
Thank you, Kara. So moving to the mitigation strategies, there are basically 2 types of strategies that are followed. One is the tactical or ad hoc approach, and the second is the strategic and training approach. Now, the tactical approach involves identifying, for example, after you get a lawsuit or a claim letter, and trying to fix it right away. This is everybody's first impulse. Oh, I have a problem. They told me what it is. Let me fix it. So you identify the problem. You get a recommendation. You pay a consultant to fix the site because you need to fix it up, and you resolve the claim. However, that typically results in falling out of compliance the very next time you post new content. So if we were to actually show the website or an evaluation of, I'm sure practically everybody on this call, including maybe even ISBOA, we would probably find that there is a problem on the site. And if I say, okay, you have 5 low contrast errors, you say, okay, let me go fix them. So you go ahead and you fix them. And then all of a sudden tomorrow, somebody else puts some content on your site and posts something. Well, they might not have fixed the underlying problem, or they might be introducing a new problem. They're not fixing the cause. They're just addressing the result. And you can quickly fall out of compliance the following day. Can you go to the next slide, please? So then there's the strategic and training approach. At least this is what we call it. It's more holistic, where the change becomes part of the organization's process. Typically, a website operator will obtain an assessment of the site and learn how to fix the current problem, same as the tactical, but they'll also be trained not to commit the same mistakes. And they'll have ongoing surveillance and training to make sure they remain in compliance. So it's not just a one-off, let me fix it today, forget about it. It's constant surveillance and training to make sure that you remain in compliance. And this is similar to the teach a man to fish adage. Obviously, the old adage is if you give a man a fish, you feed him for a day. If you teach a man to fish, you feed him for a lifetime. If you use the tactical approach and merely fix the issue that's presented, again, as soon as you post new content, you're going to be out of compliance. But if you learn how to correct the issues and make content accessible from the outset, you're likely to remain in compliance and avoid complaints. Now, in addition to avoiding lawsuits, what I think is probably going to be more altruistic is that this should endear you to those with disabilities and discourage those looking for businesses or educators to file suit against. But remember the statistic I gave you, 5 million disabled youth, or maybe even more. Those people are going to be looking for educators who can meet their requirements. And if you can endear yourself to the community, it's going to produce a tremendous amount of business for you. Next slide, please. So from a risk management perspective, the strategic and training approach actually makes repeat claims less likely. So from an insurance point of view, and I know you're business officers here, from an insurance point of view, a risk will be more attractive to underwrite, diminished likelihood of claim. Go to your insurer, or you go to your broker, say Arthur J. Gallagher, and you say, we need to go get some insurance. Well, this is something that the brokers can pitch to the underwriters as to why you are a better risk and why you should get more attractive rates than, say, another company that hasn't proceeded through this. So the best action a company can take to endear itself to the disabled population and to avoid lawsuits is to actually establish an accessibility plan. Commit to it, including the monetary and staffing budgetary resources, and execute a mitigation and proactive strategy. Even adopting a proactive strategy, however, that's not going to be a guarantee that you will not be sued. Karen and I actually received a case a couple of months ago where our client, who was, we'll say, a local retailer in a western mountainous state, they had spent a year prior to being sued, spent several hundreds of thousands of dollars developing a new website and actually attempting to be compliant. And guess what? They got sued anyway. And then the plaintiff tried to extort a high settlement because they, had one of these gotcha moments because they found some things. So it's not a matter of if, it's a matter of when somebody's going to find you and whether you decide to, or whether they decide to sue you or go to somebody else. It's fairly expensive to hire an expert to remediate a non-accessible website. And if you follow a tactical approach, you may find yourself in a hamster wheel of high payments to experts. That's where I would say technology and AAA track. Now, before I turn this over to Lawrence Shaw, I just want to say, I don't know if there's anybody on the call who can remember back to the 80s when car theft was auto theft was at a very high rate. There was a device that came out, the club, that was a bar that would attach to the steering wheel and attach to the gas pedal, that it made it difficult for a car thief to steal the car. It took a little bit longer time to actually get through that. So what would happen is a car thief would look at a car, see if there was a club. If there was, they would move to the next car. If there wasn't, they probably would go ahead and steal that car. So some of what you're going to be hearing is also a deterrence factor, because if somebody sees that a website is in the process of mitigation or is under surveillance, they're less likely to sue that website. So without further ado, I'd like to turn the presentation over to Lawrence Shaw at AAA Track to discuss the solution to these problems, or a solution to these problems. Lawrence?
Thank you, Adam. I'm glad I wasn't referred to as the dog that barks to put thieves off. I'm the car thief himself now. Anyway, good morning, everybody. Thanks for your time. Yeah, Lawrence Shaw from AAA Track, really sort of here to talk to you, give you sort of a bit of a solution, working with Gallagher for about a year now, and also across quite a few pools, offering sort of a service through the pool to all the members. So in terms of, I suppose, a bit of background to this and sort of where it's come from. And also we've been working directly with a pool very recently where K-12s are being sued as they've sort of taken on new products, but I can go through that in a moment. But as we said, where it is at the moment is a very ad hoc approach. There's very little reporting. Software companies, which we're one of, which are probably 70% to blame, is lack of accountability. And also, it's sort of, we're in a very immature market, really. When we refer to sort of build it, when you look about physical premise and physical building, the moments when we talked about a building, ADA is explicit, wheelchair ramps, disabled spaces. But in digital, it's not. It's a lot of sort of excuses why not. You'd never sign off a building yourself. Even foundations have to be checked. We just don't have that level of maturity in digital. And really, it's about the sort of market growing up. We have widespread failure. About 94% of websites fail. So when we look at what the challenges you all face, and we see this, our background, we've been doing digital about 25 years. I've been involved in compliance for about 20. I've been involved in privacy regulation as well as accessibility regulation. Alone, we've been going for about 15 years. So it's not something we've come across, and we've seen the problem grow. And the key issue, I suppose, and when we look at what we call the sort of root cause, or what's the background to the problem, first thing is actually supporting your staff, the strategic approach. It's very difficult to train people on a very technical standard. We know that is they're the part of the problem. And probably one of the most difficult things to, I suppose, cross and actually get through is, you're buying services. So, you might be signing up to Blackboard, Seesaw, a range of these services. And I don't know if you're aware, but actually there's a responsibility to yourselves if you're taking on these services to ensure the compliance, the accessibility. And a lot of these providers have a voluntary documentation process called a VPAT. And it's your responsibility to firstly know about that, secondly be able to interpret it, and then thirdly be able to contract based on it. In a case we're just working through at the moment, we've read the VPATs of certain providers, and they make very, very nice reading if you're one of the technical guys that probably uses infrared to talk. They're not really designed for humans to interpret. But therein lies the problem, where you're contracting something you don't know about. You've also got, as you said there at the end, a lot of the KPIs, the performance indicators, the reporting, it's set by the people who want you to hear, want you to see what they see. And we've seen it in, we're working with the fire services for FARA, where the vendors will actually have pages saying you are 100% compliant, and then quite a lot of small print written in quite technical language, which is really a lot of get-out clauses, but unfortunately they're not responsible. There's been quite a plethora of implementation of sort of called quick fixes, where you put a code on your page. They don't work, frankly. You can't do this. There's no quick fixes. So briefly, bear in mind time, so we've got some questions. So what do? We're here to support those managing risk, not those looking after IT. So we've created a simple way to understand compliance reporting. We've also automated both the management of the supply chain and also individual training. We've got a database which is over 3.5 trillion data points, which we can create a pathway for somebody to follow and then manage against that. We've been doing it for about 15 years. We then wrap that up and include cost coverage for insurance and Adam and Cara, but have a number of legal teams. In terms of the service, Adam talked about the sort of car lock. I talk about the dog that bites. What the system also does, it offers you a shield for the front page of your website. It only displays once and briefly, but hopefully it's enough to deter. And then as you go through the compliance program, you build up stars. As you get more stars, more coverage. So in terms of the value for money, standard price is $100 a month. When you look at the cost of doing this, typically for an organization, it's no wonder there's it's not an excuse for a lack of compliance, but when you look at the cost of doing this, implementing supply management. And this is if you've got the skills to actually interpret the documentation. You're paying $1,000 a month just to train people and support people on this. There isn't. I think we are the first to have this sort of the litigation cover and the cost coverage through Gallagher. And in terms of the service, it's designed not to be complicated. It's designed that within the first week you can use it for an hour in the first week, and you can really start to demonstrate adjustment. And hopefully, what we're trying to focus people on is do the things, understand the very basics, get confident in this, and actually start to do it, demonstrate regional adjustment, have a system, have a service in place, have the audit trail to show what you've done. So, in summary, I'll hand over to Adam in a moment, but yes, it's an automated service. It integrates an integrated process end to end. And via a set of stars, risk is reduced as you follow your pathway to compliance. And if I could close, we'll do questions in a moment, but then I'll hand over to Adam to summarise.
We have one more summary page, right, Lawrence? There we go. So to summarize, starting the process is intimidating, but it's a process. It's not a one-time task to be completed. The best approach is a consistent monitored approach. Automation is efficient and cost-effective, but it does require client involvement and buy-in. Internal staff and external vendors must share the mission and be monitored for accountability, and AAA Track actually does that, offers that. Confidence comes from taking control, which is improving your compliance and having insurance coverage to back you just in case you get sued, and it will give you some peace of mind. Can you go to the next slide, please? So as we have moved from an industrial economy to a digital economy, online operators have been slow to recognize and adopt practices for digital operations. Web accessibility is critical to get under control. Lawsuits are coming, but by no means is it the end of compliance. We're actually endeavoring to set up more sessions for you guys to address the other issues that are present with online risks. And there's quite a bit of it. And if you think about it, if you were starting a brick and mortar business, or if you're opening up a school, when you approach the school, you have to find the proper location. When you're building, you're going to have some senior people in charge of construction and the contracts. And as you go through every phase of your brick and mortar operation, and you realize that now that we've moved to this digital economy, there are equal counterparts on the digital side that need to be addressed. So if you have any questions, we'd be happy to answer them now, or you can feel free to contact us offline. But I do want to thank you on behalf of Wilson-Elser, AAA Track, and Gallagher, as well as ISBOA, for listening to us today. Any questions?
Everybody's just sitting here thinking about their websites now.
You know, it's funny because people don't realize this. And I've spent a lot of time with clients over the last, and by the way, yes, slides will be emailed to you, but I've spent a lot of times over the last few days talking to clients about their websites. I think, with 2021 starting up, people are going back to compliance or looking at compliance and budgetary issues for the year. And people don't realize how much there is to address. And I think it goes back to the fact that this is a business, and it's no longer that a website is an ancillary part or an additional part of your business. It is your business, and especially with remote learning increasing now, this is your business. Your business is on this computer.
So, schools also maintain other sort of digital platforms beside their public facing websites. So they may have internal platforms that they use to communicate with faculty and with students. Do all of these apply to that as well?
As long as it's a place of public accommodation, this will apply. So if you have disabled students that can't get onto these sites or can't use these sites, it should apply. So the answer to that question is yes. But for example, I mean, there are things that happen on your website. Say you post images of students. There's exposure for that, and people aren't thinking along the lines of, how do I protect myself? The web accessibility is at the top of the list now as one of these areas that people are looking at. Because if you remember, you moved rapidly to a web-based platform. Well, so did the plaintiffs' attorneys. Plaintiffs' attorneys have been sitting home since March. A lot of courts have closed. Your court hearings are online. So what else are they going to do? They're sitting and playing on their computers all day. There are tools that have been created that allow these websites to check your website to see if it is accessible. And I will defer to Lawrence to explain some of those results, and he probably can pull one up very, very quickly. But if a plaintiff's attorney can pull it up in about 2 minutes and then use one of their form complaints to go after you, the dominoes just keep falling. These cases are going to increase.
Yeah, I mean,
Lawrence, do you have anything?
I was going to say, yeah, to put it into scale, we're just doing a report for Forbes on the NASDAQ. We looked at the NASDAQ in about an hour and a half, to all of the NASDAQ websites. Yeah, there's a scale of what you can do with automation. And before you ask, no, our service cannot be used by the litigious aggressive law firms, which I've been asked in the past. Yes, the service is not for those. The service is to protect against those. But yeah, I can show some results. But yeah, you can literally with any one of 20 or 25, lots of free tools on the web that vary in quality. But the problem is the regulations the regulation's not very new, but it's a very much a sort of black and white. Can people find failure? And it's very easy to find failure. I mean, it's sort of actually there is one example I've got right here because somebody asked me about it today. So if a very simple thing to look at. So this is a website through a sort of Gallagher in New Jersey. Actually, we're talking to a whole group of restaurants through the equivalent of the sort of pool over there. And this is probably one of the biggest providers. You think, oh, look at how important accessibility is. Look at how important accessibility is. Oh, we can download the white paper, a splendid white paper all about accessibility. Accessibility is really important, et cetera, et cetera. Oh, hold on, there's a question here. Make sure you can use the keyboard. Make sure you can navigate without any special support. So make sure your website's navigable. So let's have a look at their website. And one of the things that you can't do in a very simple accessibility test is they've got links here. One says overview, one says overview, and one says overview. If you imagine you couldn't see, if you're visually impaired, if you're blind, what you use is a screen reader. And what a screen reader will go to the website and it reads out the links. So it would get here, it would go bento box company, career line, etc. It go website, it would say websites, it'd say com, etc. But then it just say overview, 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 design, online ordering services. A very simple error that lots of people make, but makes the website inaccessible. And the fact that it's on a page talking about accessibility, that would be a very easy claim to file to say, well, you know all about the regulation. Well, I'm going to refer to the legal partners here, but I would suggest that's a very easy claim to file. You're saying that you're professing your expertise in the subject. You know, you're talking about the importance of it. You're saying you deal with this, and yet you fail miserably on the sort of the first hurdle. And that's and you know, we've seen cases where this sort of litigious aggression, you know, they're filing 700 to 800 cases a day. I mean, they're getting a bit more sophisticated now. They're actually having a look at the websites. Before they were just sort of, you know, fly picking, just sending the demands out. But, you know, a prime example of how easy it is to fail. And in a court, in court, there's no, or we don't seem to be seeing any sort of proportionality of claim. It's either you fail or not. But it's a relatively new market, and the aggression of the lawyers is pushing people to ensure they are supporting, you know, those less fortunate. But really, you know, it's a case of organisations being better equipped to buy better. Not be, you know, you shouldn't have to be experts in the technical detail. You know, if you have a look at the, you know, if you search Seesaw, which is quite a common sort of platform, and then you search for their VPAT, that's their declaration of compliance. I've got one of my technical guys who could sort of understand it, but, you know, yes, it's not. It does present the challenge. So that's any sort of specific questions on it all?
Here we go. There's one in the chat from Matt. He's the director of marketing at a K-12 school. Wants to know how many other teams of similar small sizes manage this from a bandwidth perspective. How do we manage all of this, I guess, which gets to some of the automation and keeping up with things. Are there recommended outsourced services that exist to manage making compliance changes to the site? So it's one of them, obviously, one of the things is identifying when you're out of compliance, right, in an ongoing fashion. And the other piece of it is continuously remedying that when you are a small staff with limited resources.
Well, it's actually, yeah. I mean, yeah, the very first thing is to actually find out where you are. I mean, until you sort of, I mean, not every website's at risk. A lot are to start with. I mean, the basics of dealing with web accessibility, although, I mean, if you ever look at the web accessibility standard, that is one of the challenges because it's so technical. But that's what we've tried to do. We've tried to dismiss all the technicalities of this and actually just focus on what's important. It's not, you know, 100% compliance because you can't be 100% compliant. But, you know, yes, that you can have a small team. But, you know, we've got clients that have maybe one or two people that handle, you know, a website for a whole, you know, municipal company, you know, municipal city. So the first thing is to sort of, I suppose, understand where you are. And then, I mean, what we've done is we've created a program. And the first thing is really deal with the important pages. So deal with the pages that people visit the first. Make sure you've got things like an accessibility policy on your website. You know, make sure get your homepage accessible. Get the access. You know, very, very common is accessibility policies which are not accessible. And once you've got to grips, and once you've got to grips with the basics, then's a good time to go and look for. And there are services, you know, South Africa, South America, India, Malaysia, and you're talking $6 to $10 an hour. And these people are experts at this subject, and you can take a report like you get from our system, or, you know, other diagnostic systems. You can take a report from our system, and they'll give you a quote to say it's going to be $15 to fix it. But, you know, once it's fixed, maintaining the basics, which is about alt text on images, label form, you know, where you've got a search box, making sure it's got a description, the actual ongoing maintenance of a website once you've dealt with it, I suppose it's like a school, you know. Once if you had an old school, it's going to take a lot of work to actually get it to a certain standard, or you build a new one. But as long as you're doing bits of it every day and you're keeping the basics maintained, that saves a lot of time. And that's the basics of accessibility. It's not the big challenge, and the vast 60 to 70% of actually being accessible is actually getting on and doing it, and actually just dealing with it. You know, yes, if you look at the standards, like I say, it feels very complex. You know, you read the VPAT statements and all this of organizations, and it's this huge, great technical area. And that's what, I mean, yeah, I've got a company, we do accessibility testing, we do diagnostics, you know, we do the government rankings in Europe, etc. But that's why we invented AAA Track, to actually demystify it all and make sure the majority of people can understand and deal with it effectively and efficiently. Does that answer the question, Matt? Matt Miller.
Great. Anybody else have any questions?
And just not to scare anybody, just to alert you, when these cases are filed, they're typically filed as class actions or putative class actions, where basically you'll have a plaintiff who will claim that they are acting on behalf of others similarly situated. Most of these claims will go away before the class is actually certified, which means that, you know, these attorneys can come back time and time again. So even if you do get sued once and you fix the problem, that doesn't mean these problems are going to go away. So whether you like it or not, you're going to need to become compliant. And when we first started this program with AAA Track, and Lawrence will tell you this, I wouldn't become involved until our firm took the appropriate steps for us to get compliant. You know, you don't want to be out there preaching compliance and not be compliant yourself. And, you know, AAA Track actually helped us get on our way towards compliance. And, you know, you start to feel good about it, because now you can look at it from an altruistic standpoint. You're doing this before you're getting a claim. And, you know, it shows that you're actually trying to be inclusive. And, you know, it was one of the things that we actually project, that it is doing the right thing. So thank you again. If anybody has any questions, Lawrence is going to be, I think, distributing the white paper as well as the slides. Am I right?
Yes, but I think, it'll be done. Yes, I'll say I've got everybody's address, but yeah, you'll probably get an email from a lady called Laura, the assistant. She'll sending out, or actually, what we could probably do is we can give you the materials to put on the website.
That's
The
terrific.
website.
That's what I was
or
going
we
to
can
say.
send them out directly.
If you send it to me, I'll take care of it. I'll put it on our website, and then
thanks.
I'll send a group email to everyone.
On how to access it. So we'll get it out to everybody, and we appreciate it. Certainly a lot to think about, something I think about, and I know everybody wants to do the right thing and be accessible. It's just daunting, as we know. But thank you so much.
Thank you, guys, and have a great day.
You
Stay
too.
safe.
Thank you.
Have a nice afternoon.
Bye-bye.